So what is the step-up of basis for property sold 10 months after someone's passing when the appraisal was $100,000 less than the sales price? Before we get to that answer, I'd like you to imagine a friend going through a what-if scenario that creeps into their lives. And they were somewhat prepared because you shared this video. We would appreciate it, as will your friend. I am Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us so together we can help some folks. Now, unless you're facing an estate tax, the estate of the person who's passed is in the estate tax area, threshold, which is not applicable to most. It is important to note that the appraisal of real property under the estate should be on the higher side of the spectrum for this purpose in reducing capital gains. So some appraisers may inappropriately think that you would naturally want it on the lower side. That was the case maybe a decade, 2 decades ago when estate taxes in different states were a little bit more relevant. And when the federal exemption was much lower, but that's not common these days, and very few families are in consideration for that estate tax complexity. So we want the appraisal for the home in and of itself to be on the higher end of the spectrum, because there's a range. So you prefer it on the higher end of the range. You can ask for another appraisal on the date of death value, first of all, from either the same party, although they're unlikely to change, or a different appraiser. But we would also at the same time suggest you get the 6-month appraisal, the 6 month after the date of death. This is called the alternate valuation date. And this is typically acceptable for this purpose, for the basis step up, okay? And if that value has gone up some, then you're crunching the difference between the value, whether it's at date of death or the 6-month value, and then the sale price. Now, if there's still a gap, there could be some capital gains due, and we would suggest you speak with the accountant at the time of reporting the sale on an income tax return about that and what they propose is best to do. But typically, you need to use the value at either death or that 6-month period, and it will be compared to the sale price, of course. Any outstanding mortgage does not matter as far as considering or determining what the capital gains will be. Basis, however, does include the closing costs for the sale. So you can include the realtor's fees, the attorney's fees, etc., when you are determining the difference between the value plus the costs, right, of the sale, and then the property purchase price. So make sure that you get maybe a new appraisal, one at the 6-month mark, and then talk to the accountant. By the way, just make sure everybody realizes you must file an income tax return for the sale of real property for a decedent, whether it's under the estate or been distributed to you and then you sell it, even if the step-up basis is the same as the sale price and there's no capital gains. You still have to report it on an income tax return. Not sure if you knew that. So we hope that you've learned something new here today and choose to share. And as always, please take care.